null and void because it was an exercise of extrajudicial power that we don't have here in Kansas and could lead to a parade of horribles that we mentioned on my opening argument.
You're out of time.
Thank you, Your Honor.
Any other questions from the panel? No. Thank you very much. Thank you very much. We'll take this matter under advisement and issue an opinion as quickly as possible. Final case this morning, In Re Eugene Parks Wise Trust. Would the parties please state their appearances?
Your Honor, yes, for the appellants, Monique Canmiller in her individual capacity and her fiduciary capacity, Michael R. Ong.
Okay, thank you.
And Your Honor, Kurt Tiedemann for the Salvation Army.
Okay, and Mr. Ong, did you wish to reserve any time for rebuttal?
Yeah, I'd like to go with 10 minutes and 5 minutes.
10 and 5. Okay, great. You may begin whenever you're ready.
Please record in my opening prepared remarks. I was going to begin with the notion that there's nothing like a will or trust case to bring convoluted fact patterns before the court, but
We've had several of those this morning, so it's just par for the course.
I've sat to the docket. I'm not gonna, I struck that. While our case, or why this will and trust case does present some dramatic and interesting facts and kind of even salacious facts of the case history, really this appeal turns on really more bland issues of subject matter jurisdiction and other parties are the required parties before the bench. So I'm going to direct it to those rather less interesting, but actually dispositive issues. I'm going to cut to the nub of the case, which is our issue number 4 on appeal, which is that the ruling of the probate court that amended or terminated or modified the 1974 irrevocable trust is a void judgment. And the time element of this is very clear under both the—
Let me interrupt you with a question. Where did the district court here base its ruling on that? The judge dismissed your claim against Salvation Army for one and only one reason. You failed to state a cause of action against Salvation Army. So why are we talking about all this other stuff?
Well, a couple reasons. Number one, I think this is an issue of law before the court. Number two, if we were to remand, because I think the judge, the district court was in error on that, failing to state a claim, and in an error on failing to join necessary parties. This gets to when it's remanded, how it's remanded, and who are the parties withstanding. And I think if there is a void judgment that infects the standing of the parties, it's incumbent upon this court. That's an issue of law. And if the court were to remand it with proper directions as to who the necessary parties are, that's why I think it's—
You have to get us to remand it first, as you just said. So can you focus on why the court erred in ruling that you failed to state a claim against Salvation Army?
Right. Well, let me get there in 2 steps. Step number 1 is count number 1 of the plaintiff's petition was to get the appointment of a trustee for a trust that had a vacancy of the office. And both the Salvation Army and the plaintiffs stipulated to an order of the court, and the court appointed a trustee. The other cases were seeking relief related to the trust or in a determination of the relative rights of the parties, my client and the Salvation Army, as to the remainder of the trust. So the issue was we had to get a trustee, and then we had to figure out the relative rights of the parties. What the judge focused on is that the relief sought by my plaintiff was not against Salvation Army. And I think that's just a plain misreading of the declaratory judgment statute, which says the court, in invoking the declaratory judgment statute, one of the roles of a court is to determine the relative rights of the parties. And we were very explicit in the relief sought in our petition that there needs to be a court ruling as to who's entitled to the remainder of this trust. Is it Monique Canmiller? Is it the Salvation Army? We also said there needs to be a determination of the court as to whether the probate court exceeded its subject matter jurisdiction in modifying the trust. So
who would have been the best party to bring into this in order to pursue those claims?
Well, count one of our petition was we got the trustee in, and it was going to be the trustee and the contesting remainder beneficiaries.
The trustee might have been a good person to sue once they were appointed for your declaratory.
Right, exactly. And
but you never did that.
Well, Your Honor, we got them appointed by the court to be a part of this action.
You never named them as the defendant.
Well, they were. It's plaintiff and defendant. They were named as a party, and then I think my discussion issues 2 and 3 on our issues on appeal is, well, when it came up to, and again, this case never had a case management conference. We never had a time period to join or not join parties or dispute about that. This was fairly early on in the history of the case, and the only really hearing, we never had a hearing before we had the motion to dismiss hearing, was whether we needed to bring the trust in as a party to resolve the issues. And as I briefed, the trust could have been brought in on 219A1 or 219A2. 219A1 would be on motion of the parties, and that's where, as you can observe in the
let's assume for a second that the new trustee was an indispensable party under 219. Is there any law that says a judge needs to name them sua sponte?
Well, I think 219A2 would say is a must. The court shall. I think that's a shall.
If someone asks the court.
When's the first time you raised the issue of joinder? Was it on appeal, or did you ever seek to have that party joined?
In the argument on the motion to dismiss part of the case, even though the trustee had been appointed by the court and was in the courtroom, the issue came up that, oh, by the way, he hadn't entered his appearance in the case. And I said, oh, well, if we need to join him as a party, if he needs to be added to the party, that's something that could be done. I think both parties, it was in the transcript, both parties discussed that issue. The court denied that, on the record, denied the motion as non-timely. And again, there hadn't been a case management conference, there hadn't been any timely element there to do it. And that's our issue with 219A1. 21902 is, I don't think anyone denies that the trustee was a necessary party or a required party. I kind of went to law school too long ago. I call them necessary and indispensable parties still. But I don't think anyone denies that the trustee was a necessary party. I don't think the Salvation Army denies that. I don't think the court denies that. The question is, it's an odd case where the court named the trustee by stipulated order, where everyone recognized the trustee was a necessary party, but the court did not exercise its authority under 219A2 to add them to a party. And I'm not finding any cases where it's undisputed that a party is a necessary party, and the court, and basically even aside our oral motion to join, the court, does not join them. We're horrible judicial economy here that we're here in November of 2000. 25 on a hearing that could have been cured by, well, should we give this up? Should we give the trustee 2 weeks to file an answer? Or 2 weeks to join the case. They didn't even have to participate. They could have just entered their appearance. So
You're saying you asked that they be joined.
I asked that they be joined, and the transcript will note that the judge denied the motion as untimely.
And you did that during the motion to dismiss.
You did that during the oral arguments of the motion to dismiss. When both parties began talking about, well, the trustee is here in the courtroom with us, but he hadn't filed an entry of appearance. So it frankly hadn't occurred to me that a court could appoint a trustee under count one of a petition, but they were not technically deemed a party to the rest of the case. It's an odd splitting of hairs there that I think was totally unnecessary.
Could you have sought leave to amend your petition?
Well, he granted the motion to dismiss. I suppose I could have. I asked, well, if we needs to be joined, why don't we have him joined? But I think that's where we have the Salvation Army really doesn't address the 6219A2 issue of joining, and I don't think Salvation Army disputes that the trustee was a necessary party. So those two, together with our issue number one about the declaratory judgment statute, the court seemed focused on my client not asserting claims against Salvation Army when it was very clearly a declaratory judgment case. And I walked through the multiple times in our petition and in our arguments where this is a determined relative rights. It's clearly on all four legs with what a declaratory judgment is there for.
Starting into your rebuttal time now, if you'd like to.
I will reserve the rest.
Okay,
Thank you.
Thank you.
Morning. May it please the court. I will argue that the district court properly dismissed this case for failure to state a claim, which is, as the court has pointed out, the only basis for the court's ruling. The petition was filed by Monique Naumiller, and she is the daughter of Donna Wise, who was the trustee. And then when Donna died, that triggered everything that happened thereafter. Monique presumably came into possession of trust records when she was her mother's executor, and the Salvation Army, there's a lot of feedback there. The Salvation Army is the residuary beneficiary. And so before any issue, if there is any part of this that's really declaratory action, it's important, I think, to know that neither the Salvation Army, the trustee, anybody was given a chance to respond or even find out whether we had any dispute ahead of time. That's why I take some issue with the notion that this whole thing was a declaratory action.
Does the petition state it's filed as a declaratory action?
I think it's in paragraph 12. It is mentioned that the court may declare the rights of the parties under a certain section.
This 1962-19A2.
I think that's right. So that is mentioned in the petition. I think the only count which comes close to sounding something like a declaratory action is the one that is asking for parentage, for a determination of the parentage. Appointment of a trustee, there's no dispute on that. We agreed to it. And then the other ones are actually for the collection of money. We want money from the trust, presumably, but it's not pled that way. It's pled against us. And
what's your argument, your response to his argument that this was a declaratory judgment action and that 6219A2, once the trustee was appointed, the judge had to join them as a party?
okay,
There's, I don't have the statute in front of me, but he
Right.
indicates there's shall language, so I'm going to
Let me
believe
skip
him.
ahead to that because I do have some notes that I wrote down on that point. Okay. First of all, there was no motion on file to join.
Right.
No motion on file. The petition is not a model of clarity, I would say. And I think when we got to the hearing, it perhaps occurred to Mr. Ong that his claims really were against the trustee. And so the first thing he says when he gets up to speak, and mind you, this is a motion to dismiss, and the motion to dismiss has been pending a long time. And the court goes through toward the end of the transcript. The transcript, I believe, is part of the record, and I'm sure it's part of the record. And he says that he goes through all of these matters, and he suggests, I think, to Mr. Ong, look, I don't know what your motion is based on, whether or not this is an indispensable party. Not even sure what your claims are. And so at that point, the court basically, and I'm not sure it's quite right to interpret what the court said as denying a motion
For joinder.
I think he's simply saying, I don't know what to do with that right now. This is, you show up at an oral argument on a motion to dismiss and tell me you think there's an indispensable party. So I think there's a couple of problems with that. First of all, like I said, there's no motion on file. Second of all, you are not too late because of the lack of some scheduling order. You're too late because you're here arguing a motion to dismiss on the merits of the case. I think it's a little bit unfair of the plaintiff in the case to accuse the judge of failing to join the party when he himself hadn't done so. Apparently, he says they hadn't thought to do so. I mean, I don't know how that can be when you're claiming money from the trust that you don't add the trust as a party. Now, as to whether or not there is appearance, it's my recollection that there was an appearance. What there was not, however, was an actual claim, a petition filed against the trustee.
The judge appointed the part of the petition was appointed trustee. We need a trustee. My mom's dead. We need a trustee now.
Right.
So the judge appoints the trustee.
We agreed to.
You agree to all that?
Yeah.
Okay.
We agreed. I mean, that was a stipulated order.
So then it's just whether the next step, does the judge require then to add the trustee as a party, or does it require Mr. Ong to make a motion to add them as a
It
party?
requires not only to make a motion, but under 60-219A, it places the burden on the pleader if there is someone who should have been joined who is not joined. The motion on the pleader is to plead why that person has not been joined and why it's okay to go ahead without that party. So if you're going to blame the judge for having failed on a motion to dismiss, not to join someone, you can't ignore the fact that it was the burden was on you to begin with, to identify that party and explain to the court why that party was not, or why you can go forward without them, or why they need to be joined. So that it's not just the fact that there was no motion. And again, the court didn't get into this because frankly, the court didn't have the opportunity to look at it in any great detail. But the truth of the matter is the burden's on the pleader, not on the court to just sua sponte, come up with this, figure out the case, try to figure out what it is you're claiming, and to just add somebody. That's not the burden. The burden's on the pleader first and foremost, and that burden was not sustained. I want to be clear about something. Neither I nor anybody else stipulates to the fact that this is an indispensable party. Might be, might not be. I don't think we know even today because the motion was not preserved and it was not made. I take no position whatsoever on whether or not there was an indispensable party. We honestly don't really ever get to that. I do want to say one thing, and I've skipped some things, primarily because I see where the court's interest is, and I think, state some things that are rather obvious, but I'll skip those. I do want to address this issue, however. I mean, lack of jurisdiction, that's not something that the court ever articulated. It's one of the final arguments that Mr. Ong makes in his brief, and that is that there is an implicit finding barring the case under KSA 60-260.
Mhm.
And that applies to the notion that his client is or might be an heir. Relief from a judgment comes only under 60-260. That is true. And that was the original basis of my motion on that particular count. And that statute gives 6 reasons why you can claim relief from that judgment. And I'm not watching my time, so I have no idea where.
Yeah, you're fine.
Okay. The first 3 are mistake, newly discovered evidence, or fraud. If you go through the petition, what's being pled is that Monique Naumiller learned this fact. She learned about this document. She learned about that fact. Okay. So we're talking now about a probate judgment that's 22 years old at the time. I don't know any way you could read that other than pleading. 260 is not mentioned in the petition, but if you were to apply 260, which you must, I think, the only way you can understand that is a claim that there's newly discovered evidence. That claim has to be made within a year. So although the court did not explicitly base the dismissal on 60-260, he certainly could have. He certainly could have and would have been perfectly justified in doing so. Monique Naumiller is not an heir. The probate order was entered in 2001. If you look at that order, paragraph 8 says Eugene Parks Wise had no surviving heirs. No surviving heirs. I think we're pretty much done there. Even if we could get past the question of whether or not there was a declaratory action pled for that particular claim, even if you could get past that, the court would have been fully justified in saying, hey, we have this judgment that's 20 years old that says your client's not an heir.
And mom was the trustee.
And mom was the trustee. Mom was a party to the
One question.
to the probate case.
You don't have to answer this if you don't want to, but just tell me, are we talking about a significant amount of money here?
Gosh, I can't remember exactly. You know, my recollection is it's like about $1 million, maybe not quite.
Okay.
Okay. Again, you probably shouldn't
Just
rely on that, but that's
right,
my
I know.
recollection.
I'm just trying to figure out what motivation, I guess.
Yeah, but I think that's the answer. The other thing is that order back in 2001 says that upon the death of Donna Wise, everything passes to the Salvation Army. Now that's the part that Mr. Ong would like to say that, well, that's void. Well, again, if that's your claim, then that should have been the basis for challenging the order. This is a void order.
Right.
You don't find that in the petition either.
Under the 260, yeah.
Yeah. So I think the court was right in saying that there are no claims against the Salvation Army. But even if the trust had been added as a party, that would not end the problems with this case at all. Just to cut right to the chase, I think the court was right. I think there's no claims against the Salvation Army. They were the only defendant in the case at the time. It was the only issue before the court to decide. These other issues, as we sit here, are more or less hypothetical on what might have happened had Mr. Ong done it this way or that way, or any of a number of ways, which he did not. The court's order as it stands is correct, and I think it ought to be affirmed.
Any questions from parties? All right, you have your 5 minutes, Mr. Ong.
Your Honor, a lot of various issues going on. Let me, on the issue of the joinder of parties, I think the court, that the action has been well briefed, and the court can read the transcript for itself. I will direct attention to 6219A2, joined by court order. If a person has not been joined as required, the court must order that person to be made a party. It's a must. And I think the argument that the plaintiff failed to plead, well, we weren't pleading non-joinder. We didn't want the trust to not be a joinder. It wasn't the burden on us to say why the trustee shouldn't be a party. In fact, count one, we asked for the trustee to be appointed in the first place. It's just the anomaly of the trustee not having entered their appearance. We got a trustee. We got a trustee to manage the money, and the trustee has been managing the money ever since we got them appointed by stipulated order. And our petition is very clear. I'll direct the court's attention to paragraphs 51, 52, 53. 53, a determination is necessary as to the relative rights and the remainder interest in the trust as between the petitioner and respondent. I don't think I could be any more clear that we're invoking the declaratory judgment statute to determine relative rights. I don't know how else to do it. The relative rights of the parties, that's what the statute says to do. Let me go to this issue of why I think the void judgment issue is important here, because what the court, you had a 1974 trust that said the remaining assets shall go to the heirs of Eugene Wise as he may direct in his will. That's called a limited testimony power of appointment. He could reserve to his will a right to adjust the shares among parties. That's it. What his will did is it exceeded and voided that out and began to give money to an ex-wife and to a charitable beneficiary. It was a improper use of that testamentary power, limited testamentary power of appointment, and that is a per se void thing to do. The court, a probate court, had no jurisdiction to terminate a 1974 irrevocable trust or to modify the terms.
The fact that you would have been about 20 years too late, why didn't you try to move to set aside that probate judgment?
That's what we did in our petition. We said our paragraph 51, a determination is necessary as whether the will that did this was proper. Yeah, and now the time lay is only when she was clearing out her mother's house did you find these documents where Donna Wise and Eugene Wise signed documents related to their divorce. It says, oh yeah, by the way, Gene is the putative father. He reserved the right to claim her as a beneficiary on his income tax return. Only one way to do that. Only one way to claim somebody else as on your income tax return as a defendant. So those are the documents that she found. Oh, the trust in 1974, when my parents were getting divorced, when my father and mother were getting divorced, presumably because of an affair, and when my father had filed an alienation of affection lawsuit against Dr. Eugene Wise, the family physician, the pieces begin to fall into place. Who's the heir in the 1974 document? Monique Cammiller. That's why 22 years later, when she finds out for the first time that she was the intended beneficiary of this trust, that's the unique facts of this case. That and 22 years doesn't matter. It didn't harm the interest in Salvation Army. They weren't going to get anything during Donna Wise's life any state. You say, why did Donna Wise keep this quiet? Because Donna Wise got the chance to live in this house for 22 years for $1 a year. This house in Leawood, Kansas. She was adverse to the interest of her own daughter. That's what is one of the interesting facts of this case.
Whether the daughter got the residuary trust, that wouldn't have affected her mom still getting the $1 a year.
The only permissible beneficiary of the 1974 trust were the heirs of Eugene Wise.
Mm-hmm.
And at that point, Donna Wise was the ex-wife.
Mm-hmm. Right.
So,
and he said he had no heirs.
Well, no, he never said he had no heirs. The court made a finding of he had no heirs.
Okay.
But
Accepting the will.
there is information, well, the where, I don't believe the will addresses whether he had heirs or not. It's just silent on that. It just goes and says, I know I made this trust and said I had to leave it to my heirs, but I'm changing that completely. And it turned the trust into a charitable remainder trust, which there's a process to do that in Kansas to alter a trust involving charities. It involves getting the attorney general involved. There's all kinds of things that the probate court did wrong in 1974. And this is under 6260B4, a void judgment. If the probate court didn't have subject matter jurisdiction.
You mentioned that in your petition?
We mentioned that in our declared for relief that the court didn't have the authority to do that. And we pled it.
Did you say that it's a void judgment under 6260B4?
We said it's necessary for the court to make a determination on the validity of the will on that issue. Paragraph 52, a determination is necessary whether the direction of the will to the Salvation Army is valid and enforceable when the trust did not permit amendment by will other than to allocate among the heirs of Eugene Wise. So that's how we brought the issue before the court. But B4, 6260B4 is the void judgment, and that's the thing that can be raised at any time because the court lacks subject matter jurisdiction. It always has and it always will, and the judgment is always void. The day it was issued, 22 years later, 22.5, and that's the statute, and also the automatic feeder case, the Supreme Court case that said a void judgment can be attacked at any time, including for the first time on appeal. So we raised that issue at the lower court. In essence, Judge, I think that the trial court rushed to judgment on this thing. There was another way to handle it. The court, for some reason, didn't understand this as a declaratory judgment action, despite it being in the pleadings. And as I explained in oral arguments, it was a relative rights case. It wasn't one person gets another. It was doing what courts do all the time, a declaratory judgment. They appeared not to have recognized that. They dismissed it with prejudice, which, to your point about could the parties have gone back and amend the pleadings, it was a dismissal with prejudice, which was, I think, cost us to have to appeal this matter on its own. If it was just a failure to join the party, dismiss it without prejudice, allow the party to refile and join the party. That's what I think a reasonable court to do, or just continue it, tell the trustee to file an answer within 14 days and we reset the hearing. There's all kinds of remedial things that court could have done here, but they dismissed it with prejudice to bar my client access to the courthouse. As we're here on appeal.
Prejudice against Salvation Army, correct? There's nothing preventing you from suing this successor trustee right now, correct?
Well, Your Honor, we did that and the court dismissed that as well.
All right. You're talking about it would be too late to do that.
Well, we did exactly what you suggest. We brought an action directly naming the trustee, directly naming Salvation Army. The trustee answered that one, and the district court actually dismissed that case because of this case. So we tried to do it.
Did you appeal that?
Well, it just we haven't even gotten the order yet. That was just argued about 2 weeks ago. I suggested that case be stayed pending the outcome of this case. But we've got a dismissal with prejudice here, and it's just eminently unfair when I think all we want is to. I think the fact that the probate court in 2021 did something far beyond its legal statutory ability to do is a fact that I think needs to be remedied. And so we asked for two remands, a remand to the district court of that case and remand to the probate court for a proper hearing on the heirs of Eugene Wise. Thank you.
Thank you. We will stand adjourned. Thank you both for your arguments. We appreciate it. We appreciate the good briefing, and we will get decisions out on this case as quickly as we can. Thank you.